afternoon, everyone. This is the 7th in our annual Distinguished Speaker Lecture series. It is previous speakers who have delivered the lecture have included Lord Thomas, Lord Mounts, and this year we have the Master of the Rolls, Sir Geoffrey Vos. Unfortunately, due to the imminent arrival of Hurricane Beryl, this lecture is being given to a very specially selected and very small audience live in court. But the lecture is being recorded and will be available for people to watch at their leisure after the worst of the storm has passed. Despite the weather, Sir Geoffrey Vos has stayed on in order to deliver his speech, and we're very grateful for him doing that. Just by way of background, for anyone who's not familiar with the English hierarchy, Sir Geoffrey Vos is the Master of the Rolls, which is the head of the Civil Division of the High Court of England and Wales, and second only to the Lady Chief Justice. Sir Geoffrey was called to the bar in 1977, took silk in 1993, and moved on to become a judge of the High Court in 2009. Before that, I'm pleased to be able to say that he spent quite a lot of his time in the Cayman Islands, practicing before the Grand Court, and also spent 1 year sitting in the Cayman Islands Court of Appeal from 2008 to 2009. Once he assumed a judicial role in England and Wales, he sat as a first instance judge until 2013, when he was promoted to the Court of Appeal. In 2016, he was made the Chancellor, which is head of the Chancery Division of the High Court, and he was made Master of the Rolls in 2021. Since 2021, if anyone has been keeping track of his online presence, you'll be aware that Sir Geoffrey has given a number of very interesting lectures on digital technology in law. And it's an area that the Chief Justice and I are certainly very enthusiastic about bringing to bear on dispute resolution within the Cayman Islands. It is an area where, like Alice in Wonderland, you have to run very fast indeed in order to stay in pretty much the same place. Very much look forward to hearing Sir Geoffrey's current thoughts on the future for technology within the court system.
Many thanks to the Chief Justice for inviting me to deliver this lecture, and many thanks also to Justice Asif for that kind introduction. I really am so sorry that the approaching Hurricane Beryl has necessitated a filmed delivery and a slimmed down in-person event, but I really hope everyone will stay safe in the next 48 hours. So let me start by saying how truly glad my wife Vivian and I are to have been invited back to the Cayman Islands. Between 1993 and 2009, a period of some 16 years, we made very many trips here, first to appear in the Grand Court and the Cayman Islands Court of Appeal, and then to sit in the Cayman Islands Court of Appeal between 2008 and 2009. We made many friends, some of whom we've met again on this visit, and we took away many fond memories of both Grand Cayman and Cayman Brac. We very much hope to be back again before another 15 years have elapsed. Cayman really holds a special place in our hearts. Much has changed in the world since 2009. And even more has changed in the legal world in those years. Technological advancements that are relevant to the legal sector have accelerated rapidly. Yet it's truly remarkable to note that many lawyers and judges are still saying that they expect to retire before any of these changes really affect their work. I wonder if there may even be some in that category listening to this lecture. And I can now confidently say that I'm sure that none of you will be able to dodge the current developments in AI. I'll come back to that. But I want to start by saying something about my role as keeper and Master of the Rolls and Head of Civil Justice in England and Wales. When I left Cayman in 2009, having accepted a place on the High Court bench in England, I never dreamt that I would return as Master of the Rolls. The office of Master of the Rolls is a truly historic one. I'm the 98th person, actually the 98th man, I'm afraid to say, to hold that office in the last 738 years. What, however, you may not realize is that my interests in technology, AI, digital assets, and data are entirely appropriate for the office of Master of the Rolls. To make the point, there are two strands from the history of the office of Master of the Rolls that I will draw on. The first is that data has long been the foundation for the rule of law. And the second is that one of the central precepts of equity is that it epitomizes the point that predictable outcomes of the common law are not always aligned with what is just. So let's go back to 1286. At that time, the Master of the Rolls was in effect the Deputy Private Secretary to the King, who was Edward I, who reigned, as you will all remember, from 1272 to 1307. But the clue is in the name. John de Langton was in charge of the rolls, the parchment records that he kept of the King's correspondence. And because I am also ex officio chairman of the Advisory Council of the National Records and Archives, I have seen the roll that records John de Langton's appointment in a side note clipped to the side of the roll in Latin. The Master of the Rolls still has responsibility for national records and archives. Section 7 of the Public Records Act 1958 provides that the Master of the Rolls shall continue to be responsible for and to have custody of the records of the Chancery of England, and shall have power to determine where the records are for the time being to be deposited. And recently that section has given me the pleasurable responsibility of deciding how and where the coronation roll, recording the coronation of Charles III, should be kept. Section 144A1 of the Law of Property Act 1925, as amended, with which you will all be familiar, provides that all manorial documents which recorded the local civil justice of their day shall be under the charge and superintendence of the Master of the Rolls. But why were such rolls and records considered so important? It was not about the modern notion of history making. It was instead an obvious part of the rule of law. The rolls and records of England recorded who had what rights. That was mostly property rights in the early days, but the records also recorded who owed what loyalties to whom and in what respects, and when rights were in dispute, you had to check the record. The massive repository of paper and digital records held at the National Archives in Kew is a database of great international importance, because England is and remains one of the few countries to have records that survive intact for more than 1,000 years. The Master of the Rolls has a meaningful responsibility for the rolls, records, information technology, and of course the data of England and Wales. No wonder, then, that I'm interested in all things digital. The digital justice system that I'm working to create in England and Wales is effectively the contemporary emanation of the Master of the Rolls' ancient responsibilities. We're bringing together civil justice by providing coherence to the data underpinning the whole. And for this lecture, I need to take it no further than appreciating that the data that sits behind modern technologies is the very foundation of the rule of law. So with that historic start, let me jump forward a bit. The title of this lecture is simply AI Transforming the Work of Lawyers and Judges. It will not have escaped your notice that I'm often asked to speak on this subject. Lawyers and judges are seemingly keen to lap up lectures about things they understand perhaps too little, or perhaps it's just a macabre interest in what is going to happen to their jobs. I don't know, but I seem to fill that miserable slot rather well. Students of my lectures, however, will have noted that I do not say the same things every time I speak. The most important thing about being a good lawyer or a good judge is to learn from every day's experience. When I was at the bar, I always said that in a big case, you had frequently to review your tactics in the light of the changed circumstances of that particular day in court. And it's the same for judges. They need to listen even more acutely as they get older and be prepared to adjust their views in the light of new circumstances. And that's a circuitous way of explaining that technology has already radically altered what lawyers and judges need to do, and that it is likely that we are now seeing only the tip of the iceberg. If I were to summarize how my perspective on technology has changed, I would say that I have moved, perhaps imperceptibly, perhaps perceptibly, from being what one might have rudely called the shock jock of the judicial world to being an advocate of the middle ground. And I will in this lecture explain what I mean. I judged a few years ago, sometime before I became Master of the Rolls, that the legal community was neglecting the importance of technology. It was imagining that it was immune from changes to their working practices, and it was wrong, as we can already see. I've been at the forefront of explaining that the adoption of digital technology in every sector will dramatically affect both the work that lawyers do and the ways in which they do it. It can't now be seriously doubted that the cases we will be doing will be quite different in a digital era. Some types of fact will be far less capable of dispute. Everything is now recorded visually, or as a video or photograph or on-chain, and available through your various mobile devices. The law, like information about the weather, restaurant reviews, or even people's personal lives, are far more readily available. AI, used by both lawyers and non-lawyers alike, makes that mass of information more intelligible. Things will not be the same. I really embarked about thinking about change in 2016 when I became Chancellor. The second stage of the change has begun more recently. Technological changes were thrust into the limelight with the advent of ChatGPT in March 2023, and I pause to realize that was only 15 months ago. In that short time, almost every lawyer has tried using a large language model and discovered how clever they are. An extraordinary number have expressed concluded views about how they will be no use to lawyers because they hallucinate or are based on inaccurate information or biased or inaccurate in other ways, so that human professionals could never be replaced. Now, I don't want to get into that specific debate this afternoon. Instead, I want to try to demonstrate the importance of understanding what we will all really need to be doing once AI properly takes off in the next 2 years. Because, to put the matter colloquially, you ain't seen nothing yet. So that, after a very long introduction, is what I want to talk about. To break it down, I want to say something first about the technology and what it can and will be able to do. And then I want to ask what lawyers and judges will need to be doing differently in a world of AI in general and artificial general intelligence in particular. And I will conclude with some ideas about how we might all preserve our sanity on that journey. But I'll take as my starting point the conclusion of my lecture to the Professional Negligence Bar Association on the 22nd of May this year, when I said there are certainly dangers in AI, but we will not avoid them by ignoring technology, as some in the legal sector seem keen to do. Our clear obligation is to follow the path of justice and the rule of law, to educate lawyers, young and old, about the risks that AI poses, and ensure that all lawyers are trained to know how to use and how not to use AI. So let me say something about technology now. I'm not sure that many lawyers really understand the things that have changed in the last 25 years. When civil justice was reformed in 1999 through the work of my predecessor, Lord Woolf, the internet was in its infancy, digital assets and cryptocurrencies didn't exist, quantum computing and virtual reality were unimaginable, and the large language model had not been invented. But now all these things are realities. Lawyers seem to find it hard to see why that should affect what they do. Let me try to explain. Digital assets are critical to international trade. Astonishingly, in 2024, international sales of goods and international transportation transactions are still mostly using paper documents, paper bills of lading, paper bills of exchange, and fiat currencies. This cannot really last long, now that everything can be done more quickly and more cheaply using digital trading. In the UK, we've recently enacted our Electronic Trade Documents Act 2023, which allows for the digitization of international trade governed by English law. Other countries led this initiative, and many more are following suit. Commercial lawyers will need to understand the legal consequences of digital transacting. Then, large language models. When LLMs burst on the scene with the launch of ChatGPT, lawyers thought they were fun. You will have read about the US lawyer, Mr. Schwartz, who immediately set ChatGPT to work to write his submissions to Judge Kevin B. Castell in the New York court. I had the honor of meeting Judge Kevin B. Castell only a month ago. Mr. Schwartz did not trouble to check whether the cases that ChatGPT cited really existed. He didn't understand, of course, how an LLM worked, drawing on vast data sets to find the next most likely word. Unfortunately for the hapless Mr. Schwartz, he was rumbled and fined for citing non-existent cases. No doubt other lawyers will have been made more cautious by his experience. But the important thing to understand about LLMs is that now, 15 months after they became widely available, they are far, far better than they were then. The new ChatGPT 4.0, Microsoft Copilot, Gemini, and Claude are fantastically improved. I will return what they can actually do for lawyers and judges in a minute, but the accuracy of these machines has improved exponentially. And that's not to say, of course, that they do not still hallucinate sometimes, but the incidence of that hallucination reduces all the time. I heard a lecture the other day from Professor Felix Stefek, a great expert in this field, who explained how his research demonstrated that LLMs are far better than a conventional Google algorithm at identifying case outcomes from a case report or summary. Perhaps, though, the thing we most need to take on board in this twilight period for AI is that much, much more powerful machines and programs are on their way in the coming period of months, not years. We are, as I understand what Microsoft and OpenAI are saying, on the verge of artificial general intelligence. Artificial general intelligence is likely to be able to digest vast tracts of case information, case precedents, statutes, and provide reliable legal advice for clients almost instantly. A frightening prospect for lawyers and judges alike. We need, as I keep on saying, to be prepared for when these developments become a reality, because they really are not far away. And it will not be possible for us to suggest that nobody should touch such technology with a barge pole, because legal advice that is cheap, if not free, will be attractive to individuals, consumers, and businesses alike. I hate to tell you that nobody likes paying lawyers' fees. So what then will lawyers and judges be doing differently in a world of intelligent machines? The answer to the question, to that question, is that it depends who you ask. And I would say it depends on whether we prepare ourselves properly for what is to come. I can divide my answer really into two parts. First, what can we as lawyers and judges sensibly contemplate using AI for now? And secondly, how can we prepare ourselves for a world in which machines will be able to provide legal advice more quickly and perhaps more effectively than we can? As to the first question, what can we sensibly contemplate using AI for now? Let's take it in stages. AI can and does draft contracts of all kinds extremely effectively. If you've not tried the latest programs that do so, I suggest you do. Even ChatGPT can draft a passable contract of employment in seconds, which you can amend and use, having checked that it reflects your instructions. Lawyers are already adopting LLMs to suggest, shorten, or expand contractual terms to good effect. Is this process dangerous or the start of a slippery slope? Well, I don't think so, because a good lawyer will always check their work product before allowing their client to use it, and that's perhaps the key to what I shall be saying in a minute. What else can AI do? AI can summarize documents and text very accurately in seconds. Why, one might ask, would a lawyer employ a paralegal to take hours to read, digest, and summarize a set of case papers when a summary can be produced by an AI tool in seconds? The answer to that question, of course, depends on two further questions. How accurate is the summary produced by the AI as opposed to the human? And does it matter if the case summary is not 100% reliable? I can give an example of something we do in the Court of Appeal in England and Wales. In our court, we ask our case lawyers to provide an introductory summary for each case we receive for permission to appeal and for each substantive appeal. The summaries don't need to be totally accurate. They're just used by the judges as a way of getting into the case. They're not used for judgments or anything else directly. They move the judge a little further along their introductory path more quickly than they would otherwise proceed. This process might be one more example of a situation in which AI could be safely used, particularly if the summaries it produced were of comparable accuracy to those produced by humans. AI can already be used to identify cases that may be relevant for consideration in terms of legal research. It can do much more, of course, but it must be unobjectionable to use AI to identify legal materials that the lawyers ought to be considering. LLMs can, as I've said already, summarize a decision with a high degree of accuracy. The danger here is that one may not know when the summary is accurate and when it's not. But that danger exists when paralegals do the summaries. So the use of LLMs to summarize cases may ultimately depend on training lawyers to understand how to use work products that can never be 100% reliable, and on finding ways to check the accuracy of what is produced. So next, we come to the use of AI to provide actual legal advice and to produce actual judgments. Now, this can already be done. But as I've said, the AI's legal advice, and I suppose the judgments, will become even more reliable and effective if the big tech companies' predictions about their future product development are to be believed. But this is really the nub of the problem we face. AI will be capable soon of producing both legal advice and judgments. That is beyond doubt. What, however, is more doubtful is whether AI should be used for those purposes. And if it is used to advise or to prepare judgments, how will we evaluate the reliability and accuracy of that advice or judgment? And how will we train our young lawyers and judges to advise their clients or deliver judgments in a world where machines can match their intelligence, perhaps exceed it, and produce advices and opinions more quickly and far more cheaply than they can? Now, these are real questions for the future of lawyers, but I want to give one or two, I think, quite important, perhaps simple, maybe simplistic answers this afternoon. The two questions I've been asking are related. As lawyers and judges, we cannot willingly allow clients and the citizens we serve to receive bad advice or bad judgments. Our job is to ensure that they have the best advice and the best independent judgment from an impartial judge. So the first question is how to evaluate whether an AI's advice is good, bad, or indifferent. This is difficult and will become more difficult. Professor Stiffek's research shows that machines are even now nearly as good as humans at certain legal tasks. But what is good? And are these tasks, such as summarizing case outcomes, really the totality of what we do? As I see it, we will need to concentrate on the evaluation of the AI's work product. We will need to work quickly to establish how to evaluate the accuracy, the bias, and the quality of AI's legal advice and even legal judgments. Legal judgments are, of course, not very different to case outcome predictions that have been used for years in the US. Until we can be sure that we understand the quality parameters of AI-generated advice and judgments, it would be undesirable, I think, willingly to allow clients and litigants to rely on them. So that brings me to the real question. When should lawyers allow their clients to use AI to advise them? And when will judges use AI to produce judgments? Put another way, how should lawyers react to machines when they become more capable than them? And I really have thought a lot about this question, and I've been talking about it for some time. But I no longer think an apocalyptic approach is appropriate, and I'm going to try and explain why. People are cautious of technology, as I've said several times, and that includes lawyers. But that caution is perhaps not as misplaced as I, anyway, originally thought. It's all about confidence. People only change and do things differently when they have confidence in the new working practices or the new technology. And many technologies have not, to date at least, achieved that public confidence. Now, the example I often give concerns self-driving vehicles. They've been capable of operating quite effectively for years now, yet people still seem to prefer sitting at the wheel of the car rather than snoozing in the back seat whilst the AI does the driving. For myself, I can see where they're coming from. We should capitalize on the cautious nature of humans. Another example is supersonic aeroplanes. We can travel faster than the speed of sound, but the risk-reward balance means that our societies have generally chosen not to do so. People will only be prepared actually to rely on the advice of machines or to accept judgments of machines when they have confidence in those machines to do those jobs. Our jobs as lawyers and judges are actually not that simple. I've said for years that people are most unlikely ever to have confidence in a machine deciding whether their child should be taken from them. Just one example. And here I draw on the second of my earlier historic threads about equity. The masters of the rolls do not just have their historic roots in the literal certainty of outcomes offered by the common law and a clear record. Instead, masters of the rolls were in the vanguard of those developing equity as part of the curia regis, the law of the king. Even in the Middle Ages, litigants balked at the severity and certainty offered by the common law. Sometimes an outcome needed empathy and moral judgment, perhaps even a human touch. I think it's the same today. This may give you confidence that family lawyers, at least, are unlikely to be replaced by machines anytime soon. The machine's greatest weakness is its lack of human empathy. Machines cannot laugh, machines cannot cry, they cannot grieve. They can be taught to imitate those emotions, but they cannot be taught to understand human empathy. A large language model may predict from the mass of current legal data the next word in a judgment better than we can, but it cannot feel whether the outcome is just, nor can it distinguish an historically based legal certainty from the immediate context of the case or the people involved. So perhaps this lecture resolves itself into the practical question of what we as 2024 lawyers and judges ought to be doing to make sure that the truly astonishing power of AI and perhaps other even more amazing new technologies that are on the horizon are used for the good of our citizens and the clients we serve. I think the answer to the question of how we are to achieve this is to be derived from first principles. I think that all of us in the legal sector should be guided by justice and the rule of law. You may think that sounds trite, even old-fashioned. But I suspect, at least I hope, that every one of us here decided to become a lawyer for humanitarian reasons. We wanted, and I hope still want, to help humanity and provide real access to justice in a rules-based society where the rule of law prevails. Now that sounds airy-fairy, perhaps unrealistic in our modern, hard-nosed societies, but I think it is absolutely fundamental to the future. The rule of law is about making just solutions available to all our citizens and businesses without fear or favor. These principles translate in the AI space into developing mechanisms to prioritize a series of objectives. First, we need to train our lawyers to understand how AI operates and what precisely at any given time it can do well and what it does less well or does very badly or not at all. The old idea that it was not possible to look under the hood of AI, that one cannot see into the black box, is not really true. We do know how the machines operate, and we do know what they are doing. As part of this, we can and should be careful to identify the data sets on which the machines have been trained. Information remains the bedrock of so much in the law. It will be necessary for lawyers, as much as any other professionals, to understand what the machines they are using are actually doing, what data they're using to do it. And that's really the starting point for the evaluation of the reliability of the machine. Secondly, we need to invest time and trouble in understanding, once we've evaluated the products of AI, how to compare them with the outcomes of human work in the legal field. Now, this is vital if we're to understand whether AI for a particular operation is valuable, problematic, or dangerous. I've already said that people will not want to pay for what they can get free, but that generalization has limits, particularly when it comes to justice itself. So people will, I believe, be prepared in the future to be guided through the intricacies and complexities of machine learning, AI, and its outcomes. In a very real sense, people will need lawyers to explain to them what they can and should safely be automating, and what they definitely should not be automating. And in this space, lawyers will more than ever need to be careful not to be guided by self-interest. As I've already tried to demonstrate, there are many applications, and there will be many more, which AI can and should be used to save time and money safely and appropriately. And there will also be regulation. The EU has already passed its AI Act, and the US is regulating proactively. My own view is that regulation is better when it's applied to real current problems than to future perceived issues. Thirdly, we, the lawyers, need to take time to understand how we can best add value in a world where some of the basic tasks are undertaken by machines. Now, this has happened before. It's no different to the Industrial Revolution. People in times past were cautious, suspicious, and reluctant to adopt the use of trains, motor vehicles, aeroplanes, even the internet. Slowly over time, they've become used, mostly, to these things and realized their value. They've understood how to use them and improve their lives, and have developed confidence in them. They have shunned, for example, for perfectly sensible reasons, not only supersonic travel, but vertical take-off taxis in towns and cities, even though the technology has existed for years. People are very good generally at balancing risk and reward, and I believe they will do exactly the same with the use of advanced AI tools in the delivery of legal advice and judgments. There will be some processes that we will all come to understand and to use to streamline the delivery of legal services, and there will be other processes that will be possible, but will be far less likely to gain a sufficient groundswell of public confidence to warrant adoption. We cannot say now where the line will be drawn, but it will certainly not mean that lawyers and judges will be able to refuse to adopt AI at all. Before I conclude, let me explore that line in just a little more detail. At the moment, most lawyers and judges are pretty horrified at the thought of feeding their case papers into a machine, pressing a button, and obtaining a fully formed letter of advice or judgment out the other end. The line is being drawn well short of that point in most countries, but perhaps not all countries at the moment. I won't mention them, but there are countries where this is happening with lawyers and judges alike. But as I've said, such things are, or at least will soon be possible. But perhaps the old saying, garbage in, garbage out, best describes why we may be worrying anyway a little unnecessarily. How are you going to feed your case papers into the machine? Even simple cases require inputs from numerous sources. It's identifying the right and most relevant and significant data points or data sets and accurately assessing the human situation that actually distinguishes a good lawyer from a bad one. I'm spending much time at the moment as chair of the Online Procedure Rules Committee, working out how AI can be used to assist those going into our digital justice system to identify the real or central legal problem that requires resolution. The most important expertise of the lawyer is quite often to identify the issue in the case rather than the solution. And I should also note at this point that I'm, of course, acutely conscious of the legitimate access to justice and equality of arms challenges which AI, like many new technologies, throw up. But perhaps that's for another lecture. So our use of AI will certainly grow in countries seeking to adhere to the rule of law in line with some of the parameters I've mentioned. Lawyers and judges will start to be trained to understand the tools that are available and how they can assist their work. They will sensibly adopt those that will save time and will save their clients money, where they and their clients have confidence in them and where they can satisfactorily evaluate the outcome of the automated part of the process. Now, people will, of course, ask publicly available online AI products the answer to their legal question. They already do. But they will not so easily have confidence in the outcome. Legal problems are complex, which is why legal training has always been regarded as a gold standard. Even where legal advice is available from a machine, it will need to be explained by someone with experience of using the machine. I conclude that we will not be moving directly from a regulated legal environment to a world where legal advice and judgments are produced by machines alone. But we will need to learn about and use AI's increasingly remarkable capabilities more and more. Clients and litigants will demand that we do, but they will ultimately only demand that we use AI that delivers outcomes that are just and support rather than abrogate the rule of law. I said I'd say something at the end about how we might preserve our sanity on the journey. I think you can see that I don't think special measures will be necessary for that. When you understand that people only adopt technology when they have confidence in its ability to help their lives, lawyers will be able to move along a fairly well-trodden path. We will adopt and utilize AI for the things it does well, but we're a long way from being made redundant. So I hope I have, in a circuitous way, perhaps answered what I described earlier as the real question. When should lawyers allow their clients to use AI to advise them? And when will judges use AI to produce judgments? It will be obvious that I don't think it'll happen quite like that. Machines can do those things, but people are always likely to have greater confidence in substantive advice and judgments delivered by humans. Ours is a human system with historic roots and carefully developed principles. We will, indeed we must, increase the use of AI incrementally, but we should be guided by those principles. And if we are guided by justice and the rule of law, the result should be better access to justice, more people being able to vindicate legal rights more quickly and at lower cost, and lawyers and judges still in their jobs doing things more efficiently with the help of machines. And these outcomes are what I've been striving for in my vision of the digital justice system I mentioned earlier. That system will bring together many existing forms of online dispute resolution, ombuds portals, mediation portals, arbitration portals, consumer dispute resolution portals, into one coherent dispute resolution portal, ecosystem, not portal. Users will be directed online to the portal that is most capable of resolving their problem or dispute. But I shall leave it there for now. Thank you.